This is cause number 2021, CR 5805, the state of Texas versus Chase Hurd. Attorneys, please make your announcements for the record.
Gretchen Plater for the state.
Flavia Hernandez, defense.
Okay, Mr. Hurd, go ahead and unmute yourself and tell me your full name for the record.
Chase Michael Hurd.
That is awfully rude of me to not be on the camera. I don't know how that happened. All right, Mr. Hurd, you have a true bill of indictment that was filed against you. It alleges the offense of possession of a controlled substance and penalty group 1, 4 to 200 grams. Do you understand the charge that you have this morning?
Yes, Your Honor.
That's a second-degree felony. It is punishable by confinement in the Texas Department of Criminal Justice, the institutional division, for any period from 2 to 20 years confinement. It also carries a possible fine of up to $10,000. Do you understand the range of punishment that applies to this case?
Yes, Your Honor.
When you sign this you have the right to a jury trial. You have the right to cross-examine all the witnesses against you, and you have the right to remain silent. These are your constitutional rights. You understand those?
Yes, ma'am.
When you sign this document, Mr. Hurd, what you're telling me is you want to give up those rights. Is that what you intend to do?
Yes, ma'am.
Is this your electronic signature?
Yes, it is.
Are you a citizen of the United States?
Yes, ma'am.
If you are not a citizen, I'm still required to tell you that a plea of guilty or no contest to this charge could result in deportation, exclusion from admission to the country, or denial of naturalization under federal law. Mr. Hurd, are you satisfied with the representation of Mr. Hernandez?
Yes, ma'am.
Mr. Hernandez, does your client have a rational and factual understanding of the proceedings against him?
Yes, Your Honor.
Has he been able to assist you in the preparation of any defenses?
Yes, Your Honor.
In your opinion, is he mentally competent to waive his rights and enter into a plea?
Yes, Your Honor.
I will accept the waiver and make it part of the record. Mr. Hurd, if you take a look at the screen, I have the plea bargain agreement. The plea bargain agreement, I'm going to read it to you, and then I want you to tell me if this is your understanding. It calls for a recommendation of deferred adjudication from the state for a period of 6 years. There's a $1,000 fine. This will, the state will dismiss the other drug charge, the 1 to 4 grams, and restitution to the lab for $57. We're going to do a TAP evaluation, 200 hours of community service, and regular UAs while you're on probation. Is that your understanding of the plea agreement?
Yes, ma'am.
Mr. Hernandez, is that your understanding?
Yes, Your Honor.
Ms. Flater, is that your understanding?
Yes, Judge.
What is your plea to the charge of possession of a controlled substance, penalty group 1, 4 to 200 grams? Is it guilty, not guilty, or no contest?
No contest.
Are you pleading no contest because you have talked about this matter with your attorney and you believe it's in your best interest to do so?
Yes, ma'am.
Are you doing this freely and voluntarily?
Yes, ma'am.
Has anyone forced you to enter a plea today
No, Your Honor.
or offer you anything in exchange?
No, ma'am.
I will accept the plea of no contest. I find the plea is voluntarily made, and I will ask the state to tender its proof.
State offers State's Exhibit 1 and its attachments.
No objections.
State's Exhibit 1 is admitted. Mr. Hernandez, are you satisfied the state complied with Article 3914?
Yes, Your Honor.
I will sign the discovery acknowledgement and make it part of the record. State, State. Gretchen.
Yes, Judge.
The lab results are not for this case. Can you send me a different attachment? I'll wait for it.
I'm gonna bring it into you, okay?
Let's go back on the record, please. So just to be clear, the heroin is the case that's going to get dismissed.
Yes, Judge.
Okay. I do find the evidence is sufficient to substantiate your guilt. I will make no other findings at this time. Mr. Hurd, I'm going to grant your application for deferred adjudication for a period of 6 years. There's a $1,000 fine. The state is going to dismiss cause number 2021 CR 5804. I'll sign that dismissal now. We're going to do a TAP evaluation, 200 hours of community service, regular UAs, restitution in the amount of $57. This is a plea bargain case, Mr. Hurd. I followed your plea bargain agreement, so you do not have a right to appeal. Do you understand?
Yes, ma'am.
Okay, very well. I'm going to put you in a breakout room. You're going to sign your new conditions of probation. If you have no other holds, you should be released.
Thank you, Your Honor.
You're welcome, sir.
Thank you,
Actually, if you
Judge.
could please move them. Thank you, Mr. Hernandez. So this is part of the sticks. You need to attach it to the stick. Yep. Amy Bushmeyer, I'm ready on that. Let's swear her in.
Judge, just briefly, in regards to Tucker Markowitz, the probation officer, when I notified her of the hearing date, she told me early on she was unavailable this afternoon. She has a docket herself, so she can't be here this afternoon. I forwarded that information to Ashley and then re-urged that with Ashley last week. And so I know that Ms. Cutter is not here, but my witness is unavailable this afternoon. So could we just move it to the September date so that my witness can be present?
I'll decide that in about 45 minutes, but
Okay.
no worries.
Thank you, Judge.
She's probably in the breakout room. Can we get Ms. Bushmeyer back in here? Is she back?
Ms. Bushmeyer, can you hear me? You're on mute. You have to unmute yourself.
Yes.
Okay, can you hear me?
Yes.
Okay, you're gonna have to speak a little louder. Okay, I'm gonna go ahead and swear you in. Okay, you're gonna raise your right hand for me. Are you Amy Bushmeyer, the defendant in this case?
Yes, ma'am.
Are you familiar with the exhibits and stipulations attached?
Yes, ma'am.
You swear the same are true and correct to the best of your knowledge, so help you God?
Yes, ma'am.
Are you familiar with the jury waiver?
Yes, ma'am.
And your attorney has explained to you your constitutional rights and you understand them?
Yes, ma'am.
And it is your desire to enter this plea and waive your right to a jury trial?
Yes, ma'am.
Okay, you can go ahead and put your hand down. Thank you.
Mr. Cano, is Matthew Salazar going to take the offer I made? No. It's not here. Never mind.
Sorry about that. I was muted the whole time. Let's go on the record, please. This is cause number 2020 CR 5675, the state of Texas versus Amy Bushmeyer. Attorneys, please make your announcements for the record.
Gretchen Plater for the state.
Jeb Block for Ms. Bushmeyer.
Ms. Bushmeyer is appearing by video conference. Go ahead and state your full name for the record.
Amy Bushmeyer.
You need to put your volume up and you need to speak up.
Amy Bushmeyer.
Can you try putting your volume up on your phone, on your device?
It is all the way up on all options for volume.
Because if my court reporter can't hear you, we're not going to be able to do this. David, can you hear her? I can't hear her in here. Can you put the volume up? I can't hear her. All right, we're going to try to get through this. Ms. Bushmeyer, on the screen, I have the true bill of indictment that was filed in your case. Nope, I sure do. It alleges the offense of possession with intent to deliver, possession of a controlled substance, penalty group 1, 4 to 200 grams in count 1. So that substance is methamphetamine. Count 2 is possession of a controlled substance, 1 to 4 grams, and that's heroin. State, how are we proceeding?
No contest.
Judge, I believe we're proceeding on count 1 of the indictment. Yes, count 1.
Count 1 is a second-degree felony. It is punishable by confinement in the Texas Department of Criminal Justice. for any period from 2 to 10 years confinement. It also carries a possible fine of up to $10,000. Ms. Bushmeyer, do you understand the range of punishment that applies to your charge?
Yes, ma'am, I do.
You have the right to a jury trial. You have the right to cross-examine all the witnesses against you, and you have the right to remain silent. Those are your constitutional rights. Do you understand those?
Yes, ma'am, I do.
When you sign this document, Ms. Bushmeyer, you're telling me that you want to give up those rights. Is that what you intend to do?
Yes, ma'am.
Are you a citizen of the United States?
Yes, ma'am, I am.
If you are not a citizen of the United States, I'm still required to tell you that a plea of guilty or no contest to this charge could result in deportation, exclusion from admission to the country, or denial of naturalization under federal law. Ms. Bushmeyer, are you satisfied with the representation of your attorney?
Yes, ma'am, I am.
Is this, I'm on the screen, I have your electronic signature. Is this your electronic signature?
Yes, ma'am.
Okay, Mr. Locke, does your client have a rational and factual understanding of the proceedings against her?
She does, Your Honor.
Has she been able to assist you in the preparation of any defenses?
Yes, she has.
In your opinion, is she mentally competent to waive her rights and enter into a plea?
Yes, Your Honor.
I will accept the waiver of rights and make it part of the record. Ms. Bushmeyer, on the screen, I have the plea bargain agreement that you made. I'm going to go over it with you, and then I want you to tell me if that's your understanding of the plea. It calls for prosecution to proceed on count 1. There's a $1,000 fine. The state is recommending deferred adjudication for a period of 5 years. There is $114 that is restitution to the lab for the testing. We're going to reset this for a TAP evaluation, and we're going to follow the recommendations. 200 hours of community service, no contact order with Alfred Samersky. Is that your understanding of the plea agreement you made?
Yes, ma'am, it is.
Mr. Locke, is this your understanding of the agreement?
It is, Your Honor.
And Ms. Flater, is that your understanding of the agreement?
Yes, Judge.
What is your plea to the charge in count 1? Possession of a controlled substance, penalty group 1, 4 to 200 grams. Is it guilty, not guilty, or no contest?
No contest.
Are you pleading no contest because you have talked about this matter with your attorney and you believe it's in your best interest to do so?
Yes, ma'am.
Are you doing this freely and voluntarily?
Yes, ma'am.
Has anyone forced you to enter a plea today
No, ma'am.
or offered you anything in exchange?
No, ma'am.
Okay, I will accept the plea of no contest. I find the plea is voluntarily made, and I will ask the state to tender its proof.
State offers States Exhibit 1 and its attachments.
We reviewed it, Judge, and have no objection.
States 1 is admitted. Mr. Locke, are you satisfied the state complied with Article 3914?
I am, Judge.
I will sign the discovery acknowledgement and make it part of the record. Okay, give me just a minute, please, to review the evidence.
the story. Your motivation is often self-serving. That woman is going through.
Let's go back on the record. I do find the evidence is sufficient to substantiate your guilt, and I will make no other findings at this time. I'm going to reset this matter for a pre-sentence investigation report. No, I'm not. It's just a TAP. We're going to do a TAP evaluation. So let's reconvene August the 19th for sentencing. Ms. Bushmeyer, you have to appear in person for that hearing so that we can go over the findings of the TAP evaluation. So August the 19th, that's a Thursday, in person.
Okay.
All right. For now, you have to meet with the probation officer so she can give you instructions about the TAP evaluation.
Okay.
Ashley, if you could move her to the breakout room, please. Let's do Stanfield.
Ready, Judge.
Your Honor, may I ask if all the paperwork is in on Mr. Donaldo Nunez?
I'll check in a minute, Victoria.
Thank you.
Mhm. This goes with that one, with this one. Diego, with this one.
Miss Stanfield, can you hear me?
Yes, ma'am.
Stanfield is PSI only.
Oh, okay. Thank you.
Deputy Signado 6128, Deputy Signado 6128.
Stephen, did you get the PSI on this case?
Quite a few
And
times,
the-
Judge.
You did not?
No, I did quite a few times.
Okay. Just making sure.
So Judge, the defendant did not show up for the mental health evaluation. So I don't know if you want to reset for that or if you want to go with the TAP evaluation alone.
And I'd ask to just go with the TAP at this point, Judge.
No, I think we need to do the DDRF because if I send her, let's say, I mean, it's recommended for a residential. If I send her to what was
I'm
that?
sorry, Judge. My understanding was that DDRF, after reading the TAP eval and the PSI, some of the things that Ms. Stanfield indicated in there would typically disqualify her unless the rules have changed from MIOF or what is now DDRF, specifically previous suicidal ideations. That's always been my experience.
Is your client under any type of medication right now?
I do not believe she's being medicated at the jail. Her previous prescription for her mental health diagnoses, I think, ran out about 6 months ago. And so she's been unmedicated since then.
You're not medicated, Ms. Stanfield? Unmute yourself.
No, ma'am.
Well, I'm gonna have to, because we have waited this long for her to be in custody for us to do it, I'm going to do the DDRF. Because if she qualifies and she meets criteria, I'm gonna send her there. And I think that's better for her, a better fit for her than Safe P.
I agree with that, Judge. Like I said, my only concern was whether or not the previous issues would disqualify her from being led into that program.
I won't know until they actually talk to her. So I will know quickly on the first go around. So Bianca, when is the first appointment we can get her for DDRF?
Judge, I had emailed them. I'm still waiting on a response.
I can't hear you, Bianca.
Judge, I had emailed them and I'm still waiting on a response.
You have to speak.
Judge, were you able to hear me? I emailed them this morning at 9:30 and I'm still waiting on response for the next available scheduled date for the DDRF evaluation.
Okay, well, I'm gonna reschedule her for the next PSI date, which is August the 19th. They're gonna have to get it done. So who do I have to talk to for that to happen? We need to do it.
Judge, I can email the assessor to see how soon they can do it. It should be probably done by that since she's in custody. I just have to see how they coordinate with the Center for Care Services because they're the ones that handle the evaluation. for the
Okay,
second part.
August the 19th, we're gonna set up the DDRF. Do you need to talk to her in a breakout room?
Yes, please, Judge.
Yes, Judge. I need
I'm gonna
to
put
sign.
you and probation in a breakout room with Ms. Stanfield.
Thank you
We'll
so
see
much.
you guys August the 19th.
Very good. May I be excused from there, Judge?
Yes, thank you, Stephen. Good to
Thank you.
see you.
Good seeing you.
What are all these gnats flying around here? I'm gonna give you her trial court cert because this is a long time ago and it's hard for me to find it to go that far back, Nicole. So that way, when we come back for sentencing, I have it. I'm ready to go on Elias. Is he sworn in?
Yes, Judge.
Judge, I don't think he was, or at least I didn't notice that earlier if it happened.
Nicole did.
Yes. My clerk is saying that they did.
Okay, Judge, I'm sorry. I just didn't. And we do have a couple of things to point out to the court, Judge, before we begin.
Okay, hang tight. Let me pull up
Sure.
the indictment.
Yes, Your Honor.
So he's taking a plea on 2 cases.
That's correct, Judge. 4766 and 4769, which is a felon possession firearm. The first one is a possession on a lesser included offense.
Okay.
And Judge, that first one, 4766, the lesser included offense, it's going to be 200 to 400 grams. And on the punishment range, Judge, according to 481.112, paragraph E, the punishment range for that is no less than 10 years up to 99. But when I was doing the paperwork, Judge, I couldn't find 10 to 99 anywhere. So I went with something lower, 5 to 99 on a first, but it's actually 10 to 99.
Right, it's one of those special
Yeah.
felonies.
Correct, Judge.
Mhm.
So I just went with, I didn't want to go higher, 25 or 15. So I went lower, but it's actually 10 to 99. And then the second thing I want to point out, Your Honor, is that on the plea paperwork, I did leave out the LIO portion of it. I didn't click that, as well as the fact that it's going to run concurrent with with the other case, with the felon possession firearm, which is the,
On the 10 to 99, you're waiving habitual?
that's correct. We are as well. Yes, Your Honor. That's in the paperwork, in the plea
Okay.
paperwork.
All right, give me just a minute.
Yes, Judge. And that really is the extent of what I wanted to point out. A couple of things I left out.
Okay, so this is an agreement for 10 to do. We don't need to reset for a PSI or anything like that.
That is correct, Your Honor. And again, I did leave out the run concurrent. I put that into the felon possession firearm, but not in this case. So just, I think that's.
I saw that.
Okay, thank you, Judge.
I saw it. Okay, let's go on the record. This is cause number 2020 CR 4766 and 4769, the state of Texas versus Michael Elias. Attorneys, please make your announcements for the record.
Yes, Your Honor. Luis Echeverria for the state of Texas.
Sergio Ibarra for Mr. Elias.
Mr. Elias is appearing by video conference from the Bexar County Jail. Go ahead and tell me your full name, Mr. Elias.
Michael Elias.
Okay. This is how I want to handle your two pleas. I'm going to show you both of the indictments. I'm going to go over the two different ranges of punishment that apply, but everything else we're going to do at the same time because your rights and duties are identical in both of these cases. Okay?
Yes, ma'am.
Let's start with the possession. I'll show you that on the screen. The possession with intent to deliver a controlled substance over 400 grams is alleged in count 1. That is heroin. Count 2 is the same quantity, same drug, but possession. And then the indictment also alleges a habitual enhancement allegation alleging 2 prior penitentiary trips on those 2 cases. State, can you tell me for the record how we're going to proceed on this case?
Yes, Judge. The state moves to waive and abandon the habitual enhancement allegation, as well as to abandon count 2 and proceed on the lesser included offense of count 1, 2 to 400 grams with intent to deliver.
Okay.
And Your Honor, there are no objections to the striking of those sections of the indictment.
Mr. Cano, head back to room 12.
I'm sorry, did you say something to Ed Cano?
Yes, go to breakout room 12.
Okay.
Okay, so a couple of things, Mr. Elias. So you understand that the habitual offender enhancement allegation is now gone. They have waived it. They have also waived count 2. So we're going to proceed on the lesser included offense of possession with intent to deliver a controlled substance, penalty group 1, 200 to 400 grams. That's the offense that we're going to proceed under. The range of punishment for that offense is a minimum term of confinement of 10 years in the Texas Department of Criminal Justice and up to 99 or life. and also a possible fine of up to $10,000. Do you understand the range of punishment that I've explained to you?
Yes, Judge.
Do you understand the count that we're going on and why that range of punishment applies?
Yes, ma'am.
Okay, so let's move on to the felon in possession of a firearm. State the indictment does allege the habitual enhancement allegations. Are you waiving those?
Yes, Your Honor. Again, the state moves, in this case, ending in 4769, to waive and abandon the habitual enhancement allegation and proceed solely on the underlying count.
No objections.
So in this case, the indictment will stand on just a third-degree felony, Mr. Elia. So a third-degree felony is punishable by confinement in the Texas Department of Criminal Justice, the Institutional Division, for any period from 2 to 10 years confinement. It also carries a possible fine of up to $10,000. Do you understand the range of punishment that applies to that case?
Yes, Judge, I do.
Okay, so now that you know the range of punishment for the two different indictments that we're proceeding on, I want to talk to you about your constitutional rights. You have the right to a jury trial on all of the cases that you have pending. You have the right to cross-examine all the witnesses against you, and you have the right to remain silent. Those are your constitutional rights. Do you understand those?
Yes, ma'am.
When you sign the document called the waiver of acknowledgement, the court's admonishment and the waiver and affidavit of admonitions. This document I have on the screen. When you sign this document in both of the cases that are before me, what you're telling me is you want to give up those constitutional rights that we just discussed. Is that what you intend to do today in each of these cases?
Yes, ma'am.
Is this your electronic signature on the felon in possession of a firearm?
Yes, ma'am.
Hang on. And let me show you, is this your electronic signature on the possession with intent to deliver? Right here.
Yes, Judge.
Okay. Are you a citizen of the United States?
Yes, ma'am.
Yes, Your Honor, it is.
If you are not a citizen of the United States, I'm still required to tell you, Mr. Elias, that a plea of guilty or no contest to this charge could result in deportation, exclusion from admission to the country, or denial of naturalization under federal law. Are you satisfied with the representation of both your attorneys, Mr. Kalfas and Mr. Ibarra?
Absolutely, Judge.
Mr. Ibarra, does your client have a rational and factual understanding of the proceedings against him?
He does, Your Honor.
Has he been able to assist you in the preparation of any defenses?
He has, Your Honor.
And in your opinion, is he mentally competent to waive his rights and enter into a plea?
I do believe he is.
I will accept the waiver of rights in each of these cases and make it part of the record. Let's take a look at the plea bargain agreement that you have made, Mr. Elias. I'm going to go over it with you. Before I do that, though, if there's no objection from the parties, I am going to correct. Once I sign it, I'm going to print the court admonishments, strike through the 5 to 99, and I'm going to handwrite the correct range of punishment. Is there any objection to that?
No objection from the state, Your Honor.
No objection from defense.
All right. So let's go through the plea bargain agreement, Mr. Elias. It calls for prosecution to proceed on the lesser included offense in count 1, which is possession with intent to deliver 2 to 400 grams. Punishment agreement is to be assessed at 10 years confinement in the Texas Department of Criminal Justice. There's no applications. The state is going to dismiss. It looks like all the remaining cases that you have.
That is correct, Your Honor, and I'm working on that paperwork right now, Judge.
Two felonies, right?
2 indicted felonies. Those would be ending in 4767 and 4768, and 1 at-large case, Judge, which I will send for you to reject.
And that's the criminal magistrate 86847.
That is correct, Your Honor.
And what is this other case number? 202 4367.
That's the same case, Judge.
Oh, is that the JN number?
It's a case number noted in our JD system, and the CM is the magistrate number, the county warrant magistrate number. So I just put both numbers in there, Judge. I wasn't sure which number to go with.
Okay. And as part of your agreement, Mr. Elias, the state has also waived and abandoned the habitual enhancement allegation. Is that your understanding of the plea bargain in this case?
Yes, Judge.
And Mr. Ibarra, is that your understanding in this case?
Yes, it is, Your Honor.
Mr. Echeverria, is that your understanding in this case?
It is, Your Honor.
Okay. Okay. Mr. Elias, now I'm going to show you the plea bargain agreement in the felon in possession case. That plea bargain agreement, prosecution to proceed on count 1. The state is waiving and abandoning the habitual enhancement, 10 years confinement in the Texas Department of Criminal Justice, institutional division, no applications. The dismissal of the cases is also agreed. That is pretty much identical plea bargain to the other case. Is that your understanding of the agreement?
Yes, Judge.
And for purposes of the record, the state has already noted that these matters will run concurrent. Okay, is that your understanding, Mr. Ibarra?
It is, Your Honor.
And Mr. Echeverria?
It is, Judge.
Let's start with the felon in possession of the firearm. I have that one up. Mr. Elias, what is your plea to the charge as alleged in the indictment? Is it guilty, not guilty, or no contest?
No contest, Judge.
Are you pleading no contest because you have talked about all of your... Okay, hang on. I'm trying to see where the noise is coming from.
Oh, it's right here. We got somebody right here next to me. You want me to tell them to be quiet?
Yes, can you please tell them, we're almost done. Can you just tell them to keep it down, please?
Hey, excuse me, homie. Hey,
It's also very important to.
all right, he lowered down. I guess he's talking to somebody.
As long as you can hear me and the court reporter can hear me, that's all that matters.
Yes, ma'am, I can hear you.
Are you pleading no contest because you have talked about all of these matters with your attorney and you believe that it is in your best interest to enter this plea?
Yes, Judge.
And are you doing this freely and voluntarily?
Yes, ma'am.
Has anyone forced you to enter a plea
No, ma'am.
or offered you anything in exchange for your plea?
No, ma'am.
I will accept the plea of no contest. I find the plea is voluntarily made, and I will ask the state to tender its proof.
The state offers State's Exhibit 1 and all attachments pending any objection from Mr. Ibarra.
No objections.
Okay, States 1 is admitted. Let's move on to the possession with intent to deliver. In this case, what is your plea? Is it guilty, not guilty, or no contest?
No contest, Judge.
And are you pleading no contest in this case because you have talked about this matter with your attorney and you believe it's in your best interest to do so?
Yes, ma'am.
And are you doing this freely and voluntarily?
Yes, ma'am.
Anyone force you to enter a plea
No, ma'am.
or offer you anything in exchange for your plea?
No, Judge.
I will accept the plea of no contest. I find the plea is voluntarily made, and I will ask the state to tender its proof.
The state offers State's Exhibit 1 and all attachments pending any objection from Mr. Ibarra.
No objections, Your Honor.
States 1 is admitted in this case. Mr. Ibarra, on both of these matters, are you satisfied the state complied with Article 3914?
I am, Your Honor.
I will sign the discovery acknowledgement in both of these matters and make it part of the record. Luis, while I'm reading the exhibits, can you please send me the dismissals?
Yes, Your Honor, I'm working on the first. Yes, Judge.
Thank you.
You're welcome.
Let's go back on the record, please, on Michael Elias. Mr. Elias, before I sentence you, I think it goes without saying that given the indictments that were presented against you, you struck a very good deal in both of these cases. I mean, I see you. I think you're smiling. It's a good smile. I'm not offended by that, but it is a very good deal. And
Appreciate it,
it's
Judge.
up to me to follow it. You know that, right? I don't have to follow it.
Yes, ma'am.
Okay. But we're going to start with the possession with intent to deliver a controlled substance. We're proceeding on the count 1, lesser included offense of penalty group 1, 2 to 400 grams. I do find the evidence is sufficient to substantiate your guilt, and I will find you guilty of that offense. I will assess punishment according to your plea bargain agreement to 10 years confinement in the Texas Department of Criminal Justice Institutional Division. You do get credit for the time you have been in custody on this case. In both of these matters, Mr. Elias, you made a plea bargain. I followed the plea bargain agreement, so you do not have a right to appeal. Do you understand?
Yes, ma'am. Yes, Judge.
Okay, let's go on to 2020 CR 4769, the felon in possession of a firearm. I do find the evidence is sufficient to substantiate your guilt, and I will find you guilty of the offense alleged. And I will assess punishment at 10 years confinement in the Texas Department of Criminal Justice Institutional Division. You get credit for the time you have been in custody on this case. Both of these cases will run concurrent with one another. So this case will run concurrent with 2020 CR 4766. Mr. Elias, again, you do not have a right to appeal because I did follow your plea bargain agreement. And that is true for both cases. I am going to go ahead and sign all of the dismissals for the remaining matters. You should not have anything else pending in my court. So I will remand you to the custody of the sheriff's office to begin your sentence in these cases.
Thank you, Judge.
Anything else before we go off the record?
Nothing further from the state, Your Honor.
Okay. Defense?
Thank you. He's on mute.
Luis, you're muted.
I'm sorry.
Sergio, were you saying something?
You know, I was, Judge, and I didn't see, because the screen wasn't there, I didn't see the red microphone. My apologies. There is nothing else from defense regarding argument or anything like that, Judge, but there is I believe he does have 16 months in on these cases. I'm not absolutely positive on that, but I believe I heard the court say that that he's to receive credit for the time he has served on these matters.
Yes, yes,
Okay.
that is correct. All right, that's all I have. I signed all the dismissals. You guys are excused. So I will, I'm going to correct the admonishments and put the correct range of punishment.
Yes, ma'am. Thank you.
Okay, thank
Can
you.
I speak to you, Sergio? And
Oh, sure. Judge, if I could just get into a breakout room with Mr. Elias.
Yes.
And from
thank you,
there,
Judge. Have a nice day.
Thank you. You too, Mr. Elias.
You're both still in 5.
All right, thank you.
I can do this after the docket. All right, I'm going to go ahead and reset Mr. Margonowitz. Margozenitz. The witness is not available. Okay. Where's the probation officer?
He's in the office with me, Judge, back here.
So what days is she generally available in the mornings?
Let me ask. And I think she said Mondays and Tuesdays are best.
So I have the September, so this is the issue. I will be gone the first 2 weeks of August. That's September, sorry. The first 2 weeks of August, I'm gone. I'll be back August the 16th. And then we go straight into a panel the 24th. And that currently is the Melissa Peoples case, which will take me 2 weeks to try. So we have this week to get non-jury trial matters done. Not enough time for us to have that one heard. In September, I will be out this week, September 21st. There will not be a judge because we will all be at a conference. So we need to pick a non-jury trial week to have this matter heard. And it's looking like it's the week of September the 13th. So we could do September 13th. I know that one is jam-packed, so let's do Tuesday the 14th, and we're gonna do it at 9:30.
Yes, thank you, Judge.
So that's the next available. And yep, I will not entertain any more resets. Okay, thank you.
Judge, just for clarification, do you want that in the morning or the afternoon?
I did say the morning.
Alrighty, I'll make entries. Thank you.
Yes, defendant can go back. Yeah. There you go. Thank you. Good to see you. You too. So I only have Ronaldo Nunez and Joel Vasquez.
Yes, Your Honor. We've been waiting since 9:30.
Yes, ma'am. And I have been qualifying jurors from 8:30 to almost 11 today. We're gonna get through this as soon as we can. If I don't qualify jurors, you guys don't have panels. So that is
understand.
more important. Let me
Judge, you
see.
should also have Matthew Salazar.
Salazar? Oh, that's a plea?
Yes. And I believe also Joshua Yanchek.
No, I doubt that. He's not here. We just got his client's email real late, so that's probably going to be recalled to 1:30, Judge.
Okay, let's do that one at 1:30 because Mr. Cepeda did say he had other matters he had to go. And then, no. Yeah, Nunez, Salazar, and Vasquez. So let me see where we are with paperwork.
Judge, this is Ed Cano. I have Mr. Salazar in my office, and I think we've turned everything in, but no one's graded my papers yet. And so, but he still needs to be sworn in. So just to give you status on that.
Okay, I could definitely tell you I have Nunez, all paperwork. No, not until Nunez? No, until I confirm they have paperwork. On Joel Vasquez,
Yes,
I have everything ready to go, and that one actually came in first. So I can do Joel Vasquez, Ben Nunez, and I'll look for Salazar now.
Oh, wow. Oh, oh.
And Judge,
where did I
these are all
get
my
it?
pleas. Can the other folks
Huh?
be released?
Oh,
Yes,
swipe it?
now.
Oh, thanks, man. Oh,
All right, Judge, I'll be back on at 1:30. Thank you.
Okay, thank you. If we can tell Mr. Cepeda to appear at 1:30, Ashley, please.
Yes, ma'am.
I have everything on Matthew Salazar, so he'll be number 3. Let me get all the indictments ready and then we'll get on the record. No, this will be quick. Everything is ready.
Okay, Mr. Salazar, can you hear me?
yes, we can hear you.
Okay, I'm gonna go ahead and swear you in. Can you raise your right hand for me? Are you Matthew Salazar, the defendant in this case?
Yes, ma'am.
Are you familiar with the exhibits and stipulations attached?
Yes,
You swear the same are true and correct to the best of your knowledge, so help you God?
yes,
Are you familiar with the jury waiver?
yes,
And your attorney has explained to you your constitutional rights and you understand them?
yes, ma'am.
And it is your desire to enter this plea and waive your right to a jury trial?
Yes.
Okay, thank you. You can put your hand down.
Okay, let's get ready to go on the record on Joel Vasquez. Where is Mr. Vasquez?
I'm present, Your Honor.
Oh, he's in custody. I was looking for him on bond. Okay, let's go on the record, please. This is cause number 2021 CR 4991, the state of Texas versus Joel Vasquez. Attorneys, please make your announcements for the record.
Gretchen Plater for the state.
Miguel Nájera for the defense.
Mr. Vasquez is appearing from the Bexar County Jail. Go ahead and tell me your full name, sir.
Joel Vasquez.
Okay, Mr. Vasquez. On the screen, I have the true bill of indictment that was filed in this case. It alleges the offense of possession of a controlled substance in penalty group 1, less than a gram. Do you understand the charges you have this afternoon?
Yes, Your Honor.
Okay, that is a state jail felony. It is punishable by confinement in the state jail facility of the Texas Department of Criminal Justice, the state jail facility. It also carries a possible fine of up to $10,000. Do you understand the range of punishment that applies?
Yes, Your Honor.
You have the right to a jury trial. You have the right to cross-examine all the witnesses against you, and you have the right to remain silent. Those are your constitutional rights. Do you understand those?
Yes, Your Honor.
When you sign the document that I have on the screen, the court admonishments, what you're telling me is you want to give up those rights. Is that what you intend to do?
That is correct, Your Honor.
Are you a citizen of the, I'm sorry, is this your electronic signature?
Yes, it is, Your Honor.
Are you a citizen of the United States?
Yes, I am, Your Honor.
If you were not a citizen, I'm still required to tell you that a plea of guilty or no contest to this charge could result in deportation, exclusion from admission to the country, or denial of naturalization under federal law. Mr. Vasquez, are you satisfied with the representation of your attorney?
Highly satisfied, Your Honor.
Mr. Nájera, does your client have a rational and factual understanding of the proceedings against him?
He does, Your Honor.
Has he been able to assist you in the preparation of any defenses?
He has.
In your opinion, is he mentally competent to waive his rights and enter into the plea?
Yes, Your Honor.
I will accept the waiver and make it part of the record. Mr. Vasquez, on the screen, I have the plea bargain that you made today. It tells me the terms of your agreement. I want to go over it with you, and I want you to tell me if this is your understanding of the plea bargain. It calls for punishment to be assessed at 180 days confinement in the Bexar County Jail, and that's going to be pursuant to 1244 of the Penal Code. No fine, no application. It'll run concurrent with 663, 359, and 558-294. Is that your understanding of the agreement in this case?
Yes, Your Honor.
Mr. Nájera, is that your understanding?
Yes, Your Honor.
Ms. Flater, is that your understanding?
Yes, Judge.
What is your plea to the charge of possession of a controlled substance, penalty group 1, less than a gram?
No contest, Your Honor.
Are you pleading no contest because you've talked about this matter with your attorney and you believe it's in your best interest to do so?
Yes, Your Honor.
Are you doing this freely and voluntarily?
Yes, Your Honor.
Anyone force you to enter a plea today
No, Your Honor.
or offer you anything in exchange?
No, Your Honor.
I will accept the plea of no contest. I find the plea is voluntarily made, and I will ask the state to tender its proof.
State offers States Exhibit 1 and its attachments.
No objections, Judge. We've reviewed those documents.
States 1 is admitted. Mr. Nájera, are you satisfied the state complied with Article 3914?
Yes, Your Honor.
I will sign the discovery acknowledgement and make it part of the record. Okay, give me just a minute to review this stuff. Let's go back on the record, please. I do find the evidence is sufficient to substantiate your guilt. I will find you guilty of the offense as alleged in the indictment, possession of a controlled substance, penalty group 1, less than a gram. I will assess punishment at 180 days confinement in the Bexar County Jail, and that's pursuant to 1244 of the Penal Code. You do get credit for the time you have been in custody on this case. This matter will run concurrent with the 2 misdemeanor cases that you have. And I put those case numbers on earlier. Our records show that your client has 106 days in custody, Mr. Nájera. It's my intent to judgment satisfy him.
Thank you, Judge. I've already contacted County Court 12 as well to get his cases, remaining cases sent to jail court.
Okay. This is a plea bargain case, Mr. Velasquez. I did follow your plea bargain agreement, sir. You do not have a right to appeal. Do you understand?
Yes, Your Honor.
Okay. Once you take care of those county court cases, you should be released. On my end, there's nothing else holding you. Okay, thank you. You're excused, and thank you for your patience today, Mr. Nájera.
Thank you, Judge. Mi tripa me está tronando, so I'm gonna run.
También la mía.
Take care, Judge. Have a wonderful day.
Okay, let's do Mr. Nunez next. Mr. Nunez is sworn. Let's go on the record, please. Okay. This is cause number 2020 CR 7713, the state of Texas versus Donaldo Nunez. Attorneys, please make your announcements for the record.
Gretchen Blader for the state. Victoria Cruz on behalf of Raymond Martinez for the defense.
Mr. Nunez is appearing by video conference. Go ahead and unmute yourself, sir. You need to unmute yourself.
Can you hear me?
Yes, sir. Go ahead and tell me your full name for the record.
Donaldo J. Nunez.
Mr. Nunez, on the screen, I have the true bill of indictment that was filed in your case. It alleges the offense of driving while intoxicated, third or more offense. Do you understand the charge you have this afternoon?
Yes.
That is a third-degree felony. It is punished. I'm sorry, is there a motion by the state?
Yes, Judge, it's to proceed under the lesser included of DWI second offender.
No objection.
The DWI second offense is a Class A misdemeanor. It is punishable by confinement in the Texas Department of Criminal Justice. I'm sorry, I'm still in felony mode. I'm so sorry. It is punishable by confinement in the Bexar County Jail for any period from up to 12 months confinement in the Bexar County Jail and up to a $4,000 fine. I apologize. Do you understand the range of punishment for a Class A misdemeanor?
Yes.
Okay. You have the right to a jury trial, Mr. Nunez. You have the right to cross-examine all the witnesses against you, and you have the right to remain silent. All of those are your constitutional rights. Do you understand those rights?
Yes.
When you sign the document that I have on the screen, the court admonishments, you're telling me that you want to give up those rights. Is that what you intend to do this afternoon?
Yes.
Is this your signature that I'm showing you on the screen right here? Do you see that?
No, it's not on the screen.
It's not on your screen? Oh, I'm so sorry. I'm not screen sharing, that's why. Okay. Is that your electronic signature?
Yes.
Are you a citizen of the United States?
Yes.
If you were not a citizen, I'm still required to tell you that a plea of guilty or no contest to this charge could result in deportation, exclusion from admission to the country, or denial of naturalization under federal law. Are you satisfied with the representation of your attorney?
Yes, I do.
Okay. Mr. Nunez, I'm sorry, Ms. Cantu? Victoria, does your client, Ms. Cruz, I always call you Cantu, I don't know why. Ms. Cruz, does your client have a rational and factual understanding of the proceedings against him?
Yes, Your Honor, he does.
Has he been able to assist you in the preparation of any defenses?
He has.
In your opinion, is he mentally competent to waive his rights and enter into a plea?
Yes, Your Honor, he is.
Okay, I will accept the waiver and make it part of the record. Mr. Nunez, let's go over the plea bargain agreement that you made with the state today. The plea bargain calls for a recommendation of regular supervision, so regular probation for a period of 12 months. I'm sorry, it's not 12 months, it's 2 years. So your sentence is 1 year confinement in the Bexar County Jail, but it's going to be suspended. You're going to be placed on probation for a period of 2 years. We're going to do a TAP evaluation. There's a $1,500 fine, 200 hours of community service, DWI intervention, victim impact panel. That's going to be a live course, ignition interlock for the whole period of your probation. Is that your understanding of the agreement?
Yes, I do.
Ms. Cruz, is that your understanding?
Yes, it is, Your Honor.
And Ms. Flater, is that your understanding?
Yes, Judge.
What is your plea to the charge of driving while intoxicated second offense, Mr. Nunez? Is it guilty, not guilty, or no contest?
No contest.
Are you pleading no contest because you have talked about this matter with your attorney and you believe it's in your best interest to do so?
Yes, ma'am.
And are you doing this freely and voluntarily?
Yes.
Has anyone forced you to enter a plea today?
No.
Has anyone offered you anything in exchange for your plea today?
No.
I will accept the plea of no contest. I find the plea is voluntarily made, and I will ask the state to tender its proof.
State offer States Exhibit 1 and its attachments. No objection from defense.
States 1 is admitted. I'm sorry, Ms. Cruz, are you satisfied the state complied with Article 3914 in this case?
I am, Your Honor.
Okay, I will sign that discovery acknowledgement and make it part of the record. Give me just a few minutes, please. Oh, you mean personal custody? Okay, you said Joseph Perez, right? Before we go back on the record, is there any restitution that is due, state, to your knowledge?
Not that I know of, no.
Let's go back on the record, please. I do find the evidence is sufficient to substantiate your guilt, Mr. Nunez. I'm going to find you guilty of a DWI second offense. That's a Class A misdemeanor. I will assess punishment at 1 year confinement in the Bexar County Jail. That is suspended. You will be on probation for 2 years. There's a $1,500 fine, a TAP evaluation, 200 hours of community service. You're going to do some classes, and the first one is the DWI intervention, the VIP live, and you must maintain the ignition interlock in your vehicle for the entire period of your probation. This is a plea bargain case, Mr. Nunez. I followed your plea bargain agreement. What that means is you do not have a right to appeal. Do you understand? Yes, sir. You're muted. You have to unmute yourself again. Mr. Nunez, can you unmute yourself?
I need to help him rather quickly, Your Honor. The only thing that defense has to add is he's currently on the handheld monitor and will probably remain so, not the ignition interlock.
So that is pre-trial. He's going to have to take that up with his probation officer, execute the affidavit of non-driving, and we can alter his conditions. So the same process, just through the probation department, not pre-trial.
Okay, yes, Your Honor.
Okay, so if you could just help him unmute so I can get his response on the record.
Okay, there we go.
Mr. Nunez, did you hear me that you do not have a right to appeal?
Yes, I did.
Okay, and you understand that?
Yes.
Okay, thank you. You're gonna be asked to go to a breakout room with the probation department. So they'll set you up for your probation and give you further instructions. Let's get, was Mr. Salazar sworn?
Yes, Judge, he was sworn.
Okay, let's go on the record on his case. This is the
Okay.
last plea we have. We're gonna break for lunch. Or like my court reporter likes to say, break for dinner.
They're gonna put you in another room.
Ready, David? Let's go on the record. This is cause number 2020 CR 10126, the state of Texas versus Matthew Salazar on the charge of arson. Attorneys, please make your announcements.
Gretchen Plater for the state.
This is Ed Cano for Mr. Salazar, the defendant.
And Mr. Salazar is appearing in your office.
Yes, Judge. I don't know if you can see him on my screen, but he's right next to me.
I can see him. Go ahead and
Okay.
state your full name, sir. Ashley Move
Matthew
Nunez,
Salazar.
please.
Go ahead.
Matthew Salazar.
Mr. Salazar, on the screen, I have the true bill of indictment that was filed in this case. It alleges the offense of arson of a vehicle. Do you understand the charge that you have?
Yes, ma'am.
Okay. That is a second-degree felony. It is punishable by confinement in the Texas Department of Criminal Justice for any period from 2 to 20 years confinement. It also carries a possible fine of up to $10,000. Do you understand the range of punishment that applies?
Yes, ma'am.
You have the right to a jury trial. You have the right to cross-examine all the witnesses against you, and you have the right to remain silent. Those are your constitutional rights, Mr. Salazar. Do you understand those rights?
Yes, ma'am.
When you sign the document that I have here on the screen, what you're telling me is you want to give up those rights. Is that what you intend to do?
Yes, ma'am.
Is this your electronic signature, Matthew?
Yeah, Judge, we can't see your.
Oh, I'm sorry.
That's okay. Just so you know.
I can never tell if I'm screen sharing unless I look up there.
Yes, ma'am. Okay,
But,
we can see it now, Judge. Yeah.
Give me
Yeah,
a
we're-
minute. Ashley, please contact Victoria. Mr. Nunez needs to go to a breakout with probation.
Ashley ran out of the office. I'm trying to figure it out.
Oh. You want Diego? Diego's going to go back and help you. All right, Mr.
Your Honor.
Salazar, is this your electronic signature?
Yes, ma'am.
Okay, and is that what you intend to do today? You intend to give up your constitutional rights?
Yes, ma'am.
Are you a citizen of the United States?
Yes, ma'am.
If you were not a citizen, I'm still required to tell you that a plea of guilty or no contest to this charge could result in deportation, exclusion from admission to the country, or denial of naturalization under federal law. Are you satisfied with the representation of your attorney, Mr. Salazar?
Yes, ma'am.
Mr. Cano, does your client have a rational and factual understanding of the proceedings against him?
Yes.
Has he been able to assist you in the preparation of any defenses?
Yes.
In your opinion, is he mentally competent to waive his rights and enter into a plea?
Yes.
I will accept the waiver and make it part of the record. Mr. Salazar, let's go over the agreement that you made on this case. I want to go over it with you, and then I want you to tell me if that's your understanding of the plea bargain that you entered into.
All right.
It calls for deferred adjudication for a period of 4 years. There's a $1,000 fine. This is going to run concurrent with the misdemeanor case 658-840, and the state is going to dismiss 659-156. Restitution, if any, payable. Do we know the name of the victim?
It's the same victim with no contact, the Juanita Bonilla.
I see. Okay.
Okay.
Go ahead, Mr. Cano. What were you going to say?
Yeah, and I'll just bring this up now. That this vehicle, this is a couple involved, and so that this vehicle was something that they were both purchasing, and so it's unclear who actually had ownership because I think there might have been a default. It was like one of those, you pay and you don't get the title till you finish paying type of deals, and I don't think that was ever done. So the restitution, which we don't have a problem with, it may be confused by some of the legalities. I just wanted to make that statement.
I can make it payable to the owner, the bank, whoever held the note. But once I
Yeah.
make it payable, I cannot change it. So you guys are gonna have to tell me who to make it payable to.
I just seriously doubt that the bank is going to try to get restitution. So I just
Yeah.
wouldn't worry about it, Judge.
Yeah.
Okay. Okay, also part of the plea bargain agreement calls for a TAP evaluation, 150 hours of community service, no harmful or injurious contact with Juanita Bonilla. You're going to take a moral recognition therapy class and a DDRF evaluation. Is that your understanding of the agreement?
Yes, ma'am.
Mr. Cano, is that your understanding?
Yes, Judge, with just one clarification, is on the case that's running concurrent with this matter. My understanding is that will be JSAT.
Okay.
The
I will make,
misdemeanor. The misdemeanor.
oh, is that the understanding, Gretchen, that
Yes,
it's the
Judge.
JSAT? Okay,
Yeah, I have it in
All
the
right.
system.
all right. Otherwise, is that your understanding?
Yeah. Yes, Judge, it is.
Okay, and Ms. Flater, is that your understanding?
Yes, Judge.
Mr. Salazar, what is your plea to the charge of arson? Is it guilty, not guilty, or no contest?
No content.
Are you pleading no contest because you have talked about this matter and with your attorney and you believe it's in your best interest to enter into a plea today?
Yes, ma'am.
Are you doing this freely and voluntarily?
Yes, ma'am.
Has anyone forced you to enter a plea
No, ma'am.
or offered you anything in exchange?
No, ma'am.
I will accept the plea of no contest. I find the plea is voluntarily made and I will ask the state to tender its proof.
State offer States Exhibit 1 and its attachments.
No objection.
States 1 is admitted. Mr. Cano, are you satisfied the state complied with Article 3914?
Yes.
I will sign the discovery acknowledgement and make it part of the record.
Thank you.
Give me just a minute to read this. In the meantime, once we're done with Mr. Salazar's plea, he has to meet with probation, Mr. Cano.
Yes, ma'am. Stipulated facts.
Hello? What? Yeah. What? Good. Yeah, yeah.
What?
I don't know.
Where are
I'll
they?
back up until the 28th. Where are they?
Let's go back on the record.
Right back.
I do find the evidence is sufficient to substantiate your guilt. I will make no other findings at this time. However, I am going to go along with your agreement. I am going to add one more thing to it. I'm going to grant the application for deferred adjudication for a period of 4 years. There's a $1,000 fine. This will run concurrent with 658-840, which the parties agree will be a JSAT. The state is going to dismiss 659-156. Did you send me a dismissal, Gretchen?
No, I just said, oh, shoot, and I started doing it.
Okay, that case will be dismissed. Restitution, if any, and the restitution is going to be specific to the owner of the vehicle. So a couple of things. Probation, it will have to be the legal owner of the vehicle, and it's only for 1/2 of the claim because he was a co-owner of that vehicle. So he would have to basically reimburse the other half if there is a claim that is going to be made by any insurance carrier. So he would be responsible for 1/2 of the value that the legal owner is making.
Yes, okay.
150 hours of community service. I'm gonna hold that in abeyance. No harmful or injurious contact with Juanita Bonilla. We're gonna do a DDRF evaluation. However, because I am concerned with the facts and how the things developed, I'm going to ask that he be seen face to face, so in person, with a high-risk officer every week. Until we get the results of the evaluations, and until we know what's happening with your treatment for that, you need to see somebody in person every week, okay? This is a plea bargain case. I did follow your plea bargain agreement. You do not have a right to appeal. Do you understand, Mr. Salazar?
Yes, ma'am.
Okay, I'm going to put you in a breakout room with probation. She's going to give you instructions on what you have to do after you leave the Zoom, okay?
All right.
All right, thank you, Mr. Cano, for your patience. Thank you, everyone.
Yeah, thank y'all. Thank and appreciate the ADA's involvement. Y'all have a good day.
Yes, thank you, you too.
Yes,
So
ma'am.
let me put you in a breakout room with probation. I'm just,
Mo-
oh, you're
I moved
already
them,
there.
Judge.
You're in room 3. Thank you.
Okay, thank you.